So in this section, we're going to start finishing up what we've started a few mini lectures back, which is taking a look at the institutions of government. And we started by taking a look at Congress, and then we moved into taking a look at the presidency and presidential power. And now we're going to take a look at what is oftentimes had been called the least dangerous branch, or the Supreme Court. And today, though, the Supreme Court actually, and surprisingly, probably had you gone back in history, plays a rather large role in the political process. And it's probably something that you're even potentially familiar with. So let's talk about this. Now, unlike the other branches of government, there's a broader category of things that you're going to have to be familiar with in order to understand the Supreme Court. And that is we're going to talk a little bit about law and the lawmaking, not the lawmaking, but the law process and what law is, kind of like you might if you were a lawyer. Now, there are two basic types of law. There is criminal law and there is civil law. Criminal law is law where you deal with an individual who's being prosecuted by the state. So government is bringing charges against an individual for the individual violating some statute. Right, so there's some issue that happens. And so in this, the plaintiff, the person who's bringing the charge, is always a government. And there's always some individual who is at the receiving end of the charge who is the defendant. And this is the result of an individual potentially breaking some kind of statute. Now, civil law, on the other hand, is when you have two individuals who are suing or bringing claims against each other. So the plaintiff is one particular individual, corporation, etc., who is then claiming that another individual has violated some kind of contract. So there can be an explicit contract, or there can be an implicit contract that we call a tort. So in criminal law cases, this is where the court's dealing with a case where an individual is going to be paying a fine or spending time in jail. In civil law cases, though, we're looking for a remedy. No one's going to jail, but rather if individual two has in fact violated their contract with individual one, they might be fined or they might have to pay a penalty, right, to that individual. So you have criminal law and civil law. Now, additionally to this, we're going to need to understand a little bit about some basic court terminology. And there are four terms that you're going to have to be familiar with: precedent, stare decisis, common law, and jurisdiction. Precedent are prior cases on a given issue. So imagine that we have an issue that deals with who's liable when you're walking into somebody's store, right? So any case that deals with people who are being harmed or hurt as they're entering into a store would be the precedent for that type of case. Now, the second thing is stare decisis. Stare decisis, literally, this is Latin. If you translate it, means let the decision stand. Let the decision stand. And what it means, it's a court doctrine that says that courts should uphold their own precedent, right? So if the court a year ago said that it's the job of a store to make sure their floors aren't slippery, if somebody falls down today, the same thing should happen as it would happen a year ago, right? So stare decisis, the decision of earlier courts, should stand. Now, the third one is common law. Common law is the tradition that says that decisions made by a court have the same standing as law. So court decisions are the same thing as any other type of law. So if a judge decides something, that's no different than Congress passing one of those complicated laws that we talked about. And then finally, we have jurisdiction. And jurisdiction refers to the sphere of a court's authority. This can be both geographic, right? So there can be spaces where certain courts have. So state courts will only exist inside of that state, or sometimes even more narrow ranges than that. And it can refer to the issues that a court can take up. So you could have a court that deals with drug law exclusively or family law exclusively, and that can be part of a court's jurisdiction. Now, as a result of federalism, and we've talked about this before, and we're not going to be done yet. As a result of federalism, we actually have two separate but parallel court systems in the United States. We have a federal court system and we have a state court system. Now, both of them will have the same three basic types, but that wouldn't have to be the case. And the three basic are, you have trial courts, you have courts of appeal or appellate courts, and you have Supreme Courts. And each level will have their own trial, courts of appeal, supreme. At the federal level, we call trial courts district courts. And at the federal level, we call courts of appeal circuit courts of appeal, and then we have the U.S. Supreme Court. Now, states, you can hear these called all different kinds of things. So some state court trial courts will be district courts. But in New York, for instance, trial courts are called Supreme Courts. So it can be confusing, and we're not really going to focus over here on state land too much. We're interested in federal land. So trial courts, whether you're in the state or you're at the federal level, these are courts that have what's called original jurisdiction. Original jurisdiction. It means that they hear cases first before other courts will. In the United States, there are 94 currently district courts. So they're going to hear cases in the first instance. These are the courts where you're going to see all the action of a trial happen, right? There'll be a defendant and there's going to be a prosecutor and they're going to be arguing over the evidence and having witnesses and all of that. All of that happens at the trial court level, and at the federal level, that's the district court. Now, most cases begin and end right here with the district court, but cases can be appealed. In other words, they can move from the trial court to the courts of appeal. Now, courts of appeal, they do something very different. U.S. courts of appeal are designed to review what an earlier court did and to rule on that. So they're not rehearing cases. Rather, they're listening to cases again. There are 12 geographic districts or circuits. There are 12 circuits for the federal courts of appeal. And there is one topical one that resides in Washington, D.C. So altogether then, there are 13 circuit courts, and they hear appellate cases. Now, circuit courts can range in size from 6 judges to 28 judges, and a panel of them will review evidence and make a decision. Now, at the appellate level, meaning here, this is not what you're used to seeing. There are no witnesses, no one's introducing new evidence. Instead, you're just submitting briefs, and then the court's writing an opinion on what's happened. You can then appeal to the U.S. Supreme Court. And the U.S. Supreme Court literally means is the court of what we call last resort. Because there's nowhere else to appeal. So the Supreme Court, the decisions and precedents they make become constitutional law. And as we're going to say, the Constitution is what the Supreme Court says it is. Now, you could also go through the same process in the state system. But depending on your case, you have one last appeal process. You can appeal from your state Supreme Court to the U.S. Supreme Court. And again, this is why this is the court of last resort. So how do you make it into a court case? How do you make it? Why will a court hear your case? Well, there are some things that we call rules of access, things that your case have to have in order to be a case. Cases have to be real and adverse. The participants have to have standing. The case has to be ripe and not moot. What this means is the Supreme Court, which is what we're going to focus on, and other courts as well, will look at these factors to decide if there's a case that can be taken up. So what are these? Let's go through each of them one at a time. Real and adverse means that a case is something that's actually happening to you. So imagine if we passed the board here at Daytona State passed a rule that says that women must cover themselves at all times, right? No shorts, no skirts. It's got to always be long pants, some kind of long covering, and always long sleeves. And you might say, okay, what? Right? So, and they say this is going to start going into effect. We want to give everybody some lead time. It's going to go into effect in 1 year from today. So obviously, a lot of people would be upset. I would hope, maybe somebody say, hey, we should sue the board. This is a violation of my rights. This is a violation of my constitutional liberties. And so someone sues, and the court wouldn't hear it yet because the school actually hasn't taken the measure yet. So in other words, something has to actually happen. So the rule has to go into effect. The court does not deal with hypotheticals. The second, standing, means that the person involved has to sue, more or less. So, for example, if something happens to one of my students, I can't sue on their behalf, or I can't claim violations on their behalf. The person in question actually has to be the one to do it. Ripe and not moot are kind of similar sides, or I should say opposite sides of the same coin. Ripe has to mean that you've exhausted all of your other avenues. You don't have any other options. I always tell my students, so imagine, you're looking at your grade and you think you've got a B and A in the class, you've done the math, you think you're relatively right, and then you log in and you see that your grade's an F. You go, wait a second, this can't be the case. And so you come and you talk to me about it, and I said, oh, look, yeah, you calculated your grade right, and you're thinking, oh, well, he's gonna see that he's made a mistake, and I go, but you have failed to account for the I hate you negative points, right? I say, you've lost 30 points because I don't like you. And you're a little bit stunned. I send you out of my office, and so you go away. You're like, I'm going to sue that guy. And so you sue me. Well, the court's not going to hear that yet because there's actually an appeals process here at the college. And you'd have to go through that first before you know what the college's final decision is when you didn't have any other options. Not moot means that the court's decision must have some kind of change. So if the court decides something, it actually has to have an effect. So the court won't take up a case if whatever it decides in the end wouldn't actually change anything. So that's how you get to the Supreme Court. But where and how do you end up with the power that we think about with the Supreme Court? Well, like we normally do, we take a look at some basic things. Article 3, Section 1 sets up judicial power. And Article 3, Section 1 says that judicial power is vested in the federal court system. And that's pretty much all it says. Now, we also know that judges are appointed for life. Their salaries can't be reduced while they're in office. In other words, there's no way to poke at them. They're designed to be completely independent. And the Chief Justice, we find out in Article 3, presides over impeachment trials. But that's it. That's really all that the Constitution has to say about the Supreme Court or the court system. So what makes the court so powerful? Oops. I just can't even spell today. And it's a worthy question to take up. And the answer to this, because again, we're kind of doing the mini lecture, we can't really, we can't discuss it, is judicial review. Judicial review is the court's main and most important power. And so we need to understand what judicial review is just a little bit. Judicial review comes from an important court case, Marbury v. Madison. And I want to point out now that as we start moving forward and we start taking a look at things like civil liberties, that we're going to see that court cases are going to be a very big deal, and that means they'll also be a pretty big deal for your lectures, for your tests. So keep that in mind. Marbury v. Madison occurs in 1803, and it's a big kind of complicated deal. Let me give you the gist of it. There's more about it in your book. John Adams will become was the President of the United States, and his Secretary of State was John Marshall. And at the very last minute, when his party, John Adams' party, the Federalist Party, is coming out of power, they will pass a bill. And the bill is designed to give there to be lots more court members. And so this means that John Adams gets to appoint 42 new justices. And he appoints, including, and this is a big one, John Marshall, his former Secretary of State, to be the new Supreme Court justice. The problem, unfortunately, though, is this all happens at the last possible minute. And a number of the letters of commission get left behind when Adams leaves. And so when his successor, Thomas Jefferson, who at this point they are very much enemies, comes in, he decides, hey, I'm the president now. I don't have to deliver these commissions. Now, one of the people who was supposed to get a commission is this guy right here, Marbury. And so he does something that seems he sues the sitting Secretary of State, Madison, and demands his commission. And he demands it, and this kind of demanding is called a writ of mandamus. It's when you're requesting that somebody has to produce paperwork. And so who gets to decide this case? Well, none other than the guy who forgot to deliver the commissions. John Marshall. Undoubtedly the most important Supreme Court justice probably ever. So he needs to kind of decide on his own case. And what he ends up deciding, the long and the short of it, is that he's not going to give the commission to Marbury. But he's not giving it to Marbury because he's declaring pieces of the law that was passed unconstitutional. And this is what's going to be called judicial review. This is when the Supreme Court declares laws unconstitutional. It's not found anywhere in the Constitution. Rather, John Marshall says it just comes about by having a written Constitution, and it becomes part of precedent. And so because of this, as courts continue to uphold earlier precedent, they uphold the right to strike down laws. What this means pragmatically, though, is that the Supreme Court have the ability to determine what is and is not constitutional. And so I'm going to leave you with this. Chief Justice Charles Evan Hughes, which came much, much later, he's going to kind of perfectly sum this up. He says, we, and he means the United States, is under a constitution, but the Constitution is what the judges say it is. So laws that are found to be unconstitutional can be thrown out, which means that the Supreme Court gets to be the arbiter of what is and is not a constitutional act. And this is what makes the Supreme Court today such a much more powerful body than it has been in the past. This means that what the Supreme Court writes is a huge deal. It becomes part of law. It can overthrow other laws. There are three major types of opinions that the Supreme Court can issue: majority opinions, concurring opinions, and dissenting opinions. Majority opinions are the new decision of the court. It's the new law, the new precedent. Concurrences are decisions that agree with the bottom line outcome. But they disagree with the reasoning. And dissenting opinions are the justices who say, no, I disagree with the whole thing as it stands. So this is a big deal. These opinions are a big deal, and what the Supreme Court decides is a big deal because, ultimately, the Supreme Court determines what is and is not constitutional. And we will pause here because I've gone a little longer than I was intending.